On I'm Saksham Agrawal as Courtmaster. On behalf of Thomas George and Associates, I cordially welcome you to the fourth National Virtual Moot Court Competition. We are pleased to extend our warm welcome to Ms. Mrudulika Concepta, ma'am, and Daniel George, sir, as our judge for today's round.
Thank
Mrudulika
you.
ma'am did her master's from Osmania University, and ma'am is in the legal department of India's largest retail-led mixed-use developer, the Phoenix Mills. And Mr. Daniel sir has 12 years of experience as corporate advisor and litigation lawyer and is presently working in the in-house counsel of DLF Limited. I will now proceed to explain the time division granted to each counsel in the single team. Each team is allocated 30 minutes to present the case, and each speaker will be given 15 minutes unless indicated by the team. Play cards indicating time will be shown 5 minutes, 3 minutes prior to the lapse of time, and finally once the time has lapsed. Rebuttals are left to the discretion of the judges. We have team of Aditya Bhura and Drishti Banerjee representing the petitioner, and team of Sarthak Miglani and Vardhan Jain representing the respondents. With the permission of our learned judge, we shall commence the quarterfinal round of the fourth National Moot Court competition. And I also request our judge to please give a feedback to our speakers at the end to help them improve their performance for the upcoming rounds. And we shall begin with the competition.
Sure.
Thank you.
Please start.
May it please the court, the counsels for the petitioner have herein approached this honorable court through a public interest litigation under Article 32 of the Constitution of Indigo in the matter of Jan Seva versus Union of Indigo. With the kind consent of the bench, the counsels would like to refer to your lordship and leadership as the honorable bench.
Sure.
The counsel seeks permission to share the compendium. Given the huge size of the same, we are providing the comprehensive compendium for your very reference. Sure. So there are 3 issues on the petitioner's end. And as the first speaker, I shall be dealing with the brief legislative history and the first issue, whereas my co-counsel shall be dealing with the second and third issues. We are dividing the time limit as 14 minutes for speaker 1, 15 minutes for speaker 2, and 1 minute for rebuttals.
Okay.
With the kind consent of the bench, the counsel would like to deal with the facts of the case and the brief legislative history.
All right.
Indigo is a sovereign, socialist, secular, democratic, and a republic state, and it functions under the federal system of governance. Taking inspiration from the Westminster model, Indigo follows a parliamentary democratic form of government with a bicameral system of legislature. Here, the Election Commission is an independent body to ensure free and fair elections. The lower house of the parliament is the Lok Sabha, wherein the members are elected directly every 5 years, wherein the Rajya Sabha is the upper house of the parliament, where the members are indirectly elected every 6 years. The elected members are commonly referred to as the MPs. At the state level, we have the governor, who is the head of the state, and who is assisted by the chief minister and the council of ministers. Further, when we talk about the anti-defection law itself, with the advent of horse trading and flow crossing practices, the anti-defection law was introduced in the Constitution 52nd Amendment Act of 1985. And to avoid disqualifications under the same, splits and mergers in political parties become relevant. And this is where we talk about the legislative history of the same. So in 1967, the Chavan Committee was formed that gave recommendations to curb the practices related to defections for the very first time. And thereafter, certain amendments were brought into the Constitution of Indigo. In 1985, the landmark Constitution 52nd Amendment Act was brought in, which became Indigo's first anti-defection law. It brought in amendments to the provisions of Article 101, Article 102, Article 190, and Article 191 of the Constitution to provide grounds for vacation of seats and the disqualification of members. The 10th schedule that was inserted disqualified defecting members from the House, with an exception to splits and merger. In 1992, we had the landmark Kyoto-Holuan versus Rachilu judgment that upheld the validity of the law. And in 2003, given the widespread criticisms that the provisions of split and merger were facing, the Constitution 91st Amendment Act was brought in that removed the para 3 or splits from the 10th schedule itself. Now, in light of that, we, the Jan Seva NGO, have approached this court, filing a writ petition. Coming to the first issue, given the permission of the Honorable Bench, we will be dealing with the first issue, which talks about whether the anti-defection law exhibits notable deficiencies concerning the elements of voters' trust, thereby necessitating amendments. Shall we proceed?
Yes, please.
Yes, please.
His Lordship Justice Krishna Iyer severely criticized the electoral politics and flow crossing practices even before this very law existed. In the Narendra Mandivarlapa Kheni versus Manikrao Patel judgment of 1977, he remarked that the grounds relied on are shifting sands to build a firm finding upon, knowing how notorious is the cute art of double crossing and defection in electoral politics. The 10th schedule, which was added in 1985, was brought in under the recommendations of the Chavan Committee, and primarily was to stabilize the government and bring discipline in parliament. Further, the Kyoto Holuan judgment in 1992 was a landmark judgment. However, standing in 2023, what had been held in 1992 cannot stand true today, given the nature of floor crossing and horse trading currently. And that makes us invoke the principle of transformative constitutionalism, because that is perhaps what the Constitution still stands on. Moving on to the first sub-issue, which talks about provisions pertaining to the mergers and post-poll alliances do not stand true to the test of reasonableness. The provisions of split and merger, that is para 3 and 4 of the 10th schedule, deal with the issue of bulk defections, both of which are to be done away with. However, as per the 91st constitutional amendment, only the para 3 or split provision was removed. Now, this is not something that the council simply points out, but this was held in several committee reports, as we can point it out. Let's say the Halim Committee report in 2003, the 178th Law Commission report, the National Commission for Review of the Working of the Constitution report, and the second Administrative Reforms Commission report. All of these talk about the very same issue, which severely criticize split and merger because be it 1/3 party or the party or 2/3 party, the bulk defection was being allowed. But Honorable Court, the merger provision still remains and some continues to be misused. If we are to-
Aditya,
Yes, sir.
just I wanted to understand one thing. You have mentioned this concepts of split and merger. So does the Constitution allow any intelligible differentiate between either of these provisions as to how can you decide when something is, when one party has, had certain of its members resigning for some extraneous considerations, but not only because of the fact that they don't agree with the party
I believe
line, and what to do with when a couple of small parties they merge together.
right. Merger itself has been allowed.
Hello?
Hello.
Am I audible? Honorable Bench, am I audible?
So what is the intelligible
Yes, you are
differentiate?
audible.
What is the intelligible differentiate that you can gather between both these provisions that you're talking?
Split and merger, right? So if we were to talk about the intelligible differentiate here, split talks about only 1/3 of the party leaving, and the merger talks about 2/3 of the party. So if the party itself, let's say if 33% of the members of the party leave or below that, then that comes in the provision of split. If they do so,
Okay.
then they will be disqualified. If 2/3, that talks about a huge chunk of the party, they leave in, then it will come under merger and they will not be disqualified under the law. Because
So
that,
if I contemplate a situation where there are independent legislators in the house and they, after elections, come together to form a party, will that fall afoul of this provision or will that still stand?
so
Will
that
there
is,
be?
yes, sir. The court, that will be my very next submission in the second issue. I'll be coming to that, if I may proceed.
All right. Please go. Please do.
So, like I was talking, if we were to look at the statistics from the years of 1990 to 2004, that is a point of 14 years, we find that there have been 81 mergers, and that is a concerning number. And the numbers only keep on increasing after those years. There is not a plausible logic for keeping the merger while removing the split provision. Now, coming to the concept of post-poll alliances or coalitions, as Honorable Bench was mentioning. These governments come together only for the sake of coming into power. And given that being their only ground for coming together, they will fall in with regards to ideological clashes and eventually they fall out, causing a great harm to the very stability that the anti-defection law tried to achieve. So there have been recent cases as well for the same. If we look at the recent
Do you have any
Karnataka...
citations?
Yes, sir. Yes, sir, Honorable Bench. These are, we are presenting the same. So in 2019, we saw the Karnataka case wherein 17 MLAs from the ruling coalition resigned from the party itself. And in 2022, we saw that 40 out of 55 MLAs from Shiv Sena party, they left the coalition That was with Shiv Sena, Indian National Congress, and the National Congress Party over there. So that shows how instable the very thing becomes. So if there are no further questions, I shall be moving on to the next sub-issue.
Please go ahead.
Much of. So my next sub-issue is that the party tickets have no legal recognition. So it is submitted that the anti-defection law is premised on the candidate's loyalty to the party. However, it is to be noted that constitutional morality and social morality are not the same. As held in the Keshavananda Bharati judgment, when the parties go to election, they could promise a lot of things. And perhaps a lot of promises and diverse programs can be brought in by their words. But however, there is no law that will strip a person of the fundamental freedom to speech, fundamental right of freedom of speech. And therein, when they win a party ticket, that does not necessarily mean that they'll have to abide by everything that the party must say. This has been elaborated in the 2016 ECI report, wherein in the next page we'll find, wherein it tries to institutionalize the party tickets by placing a model code of conduct and removing this ideological conundrum. Moving on, if there are no further questions, I'll be moving on to the next sub-issue.
Please go ahead.
Now, coming to the next sub-issue, we find the intra-party deliberative and dissuading mechanisms must be enforced. Honorable Bench, it is submitted that the anti-defection law should not be brought to ensure intra-party discipline or any other political problems. If a party's member does not believe in your party's views, they may be removed from the party itself. But using whips as a mean to take their seat away is unjust, as it curtails on their freedom of speech. Perhaps we could take inspiration from their model code of conduct like that in the United Kingdom, where they are removed from the party if they do so, but they do not lose their seat therein. Moving to the next sub-issue, if there are no questions, shall I?
Yes, please proceed.
Much obliged. Moving to the next sub-issue, we talk about destabilizing the government through mass recognition has become a common practice and that needs to be addressed. Honorable Court, it is submitted that, as stated earlier, mass resignation has become a common practice, as we can see in the states of Maharashtra, Madhya Pradesh, Karnataka, Pondicherry for that matter, and this needs to be stopped. For this causes nothing but instability and makes the majority government a minority. And moving on to my final subtopic or sub-issue rather, I'll be dealing with the law has no provision for members expelled by the political parties. Honorable Bench, when we look at the provisions of the anti-defection law, we find that none of them talk about the expelled members. There exist, however, conflicting judgments on the same, with the 1996 Supreme Court judgment of G. Vishwanathan versus Tamil Nadu Legislative Assembly, wherein the Supreme Court states that the expelled members shall remain to be a member of the original party, even if they're unattached. Whereas in the 1998 Dr. Wilfred D'Souza versus Sri Tomasino Cardozo case in the Bombay High Court, it mentions that they will not be considered as a member anymore. So, Honorable Bench, as I bring my submissions to an end, this is a question that I pose to myself. What happens to that particular member? And can whips still be imposed on them? This is a question which I hope the court can shed some directions on. And I shall now request my co-counsel to proceed with issues 2 and 3. It was a pleasure arguing in front of you. Thank you.
May it please the court, this is the second counsel on behalf of the petitioner, a public-spirited NGO, Janaseva, and I shall be dealing with issue 2 and issue 3. Honorable Bench, the second issue deals with the fact that whether the right to dissent or non-recognition of the right to dissent violates the norms of a Westminster system of parliamentary democracy. Honorable Bench, if we look at paragraph 2B of the 10th schedule of the Constitution of Indigo, it lays down one of the grounds for disqualification of the member from the House. It states that if he votes or abstains from voting in such House contrary to any direction issued by the political party to which he belongs or by any person or authority authorized in this behalf, he shall be disqualified. Honorable Bench, who is this leader of the political party? For instance, if we look at Rule 2F of the Lok Sabha rules, it mentions that the leader of the political party is someone chosen by the political party, the legislature party itself. And for the various state governments, state legislatures also, there are similar rules. And this person can issue the whips on behalf of the entire party. And if a member does not abide by the whips, then he or she shall be disqualified. Honorable bench, it is a submission of this council before this court that this has no rational nexus with maintaining the stability of the government as was elaborated in the statement of objects and reasons. Because, Honorable Court, if I may refer to certain situations, for instance, vote by an opposition party member, vote by a Rajya Sabha MLA, MP, or for instance, a motion in the House that will remove the Honorable Chief Justice or the Honorable, for instance, Honorable Supreme Court Judge or the Honorable President and so on. These motions, they have no direct nexus with the stability of the government. Honorable Court, if I may refer to the landmark judgment of Keshavananda Bharati Sripada Galvaru versus State of Kerala, 1973, there also it was observed that it is hazardous to rely on parliamentary debates as aids of statutory construction, because the very purpose of parliamentary debates, that is bringing in dissents, bringing in a slew of opinions in the House, that is no longer there because the members are totally inspired by the whipping system. What the council essentially wants to submit here is that whips should not be unconditionally issued, but rather they should be restricted to confidence and quasi-confidence motions only. And these are not my words, Honorable Court. It was mentioned by the Dinesh Goswami committee, where they mentioned that only for the money bills and for the no confidence motions, whips should be introduced in the parliament. If the court has no further questions, I'd like to move on with the second part of my submissions, which essentially talks about the fact that during the disqualification proceedings, the intent of the legislator for his defection could be taken into account, because Article 105 of the Constitution, Article 122, they give the freedom of expression of the legislator. If I go by Article 105(1), it says that there shall be freedom of speech in the parliament. Honorable bench, moving ahead with this very submission, that we are in a representative system of democracy with a responsible form of government where accountability forms the basic fulcrum of the entire governance. But through this paragraph 21B of the 10th schedule, the entire accountability of the elected candidate lies towards the political party rather than towards his own constituency. Honorable bench, we are not in a proportional system of representation where the people vote for the political party, but rather people here vote for the individual candidate. Honorable Court, if I may refer to two judgments, first being Sailesh Manubhai Power versus Election Commission of India, which talks about the essential link between the voter and the representative. And moving on to the next landmark judgment, Kuldeep Nair versus Union of India, where it was held that who is a representative? A representative of the people is someone chosen by the people to represent their several interests in the parliament. Thereby, it is a submission that in a democracy where minority opinions also have equal weightage, as was recently commented by our Honorable Chief Justice D.Y. Chandrachud, that minority voices should also be given recognition in a democracy. So given all these things, we propose certain changes to the said provisions. The bench has no further questions. I'd like to move on to the last issue.
When you are talking about representative, you're saying that we are choosing a representative who is supposed to be representing us in the parliament. But how is that candidate coming into play? Only if he is choosing to be in that position, right?
Yes.
So then
See-
where is the question of, see, I as an individual, if I am feeling that I have chosen a party that I will join and I want to be part of it and I will come into power so that, I can get put across my ideas and put across my views to the public, and people like it, they vote for me. Now, if I feel that I have not liked the policies of the party with which I'm associated, shouldn't I be having the freedom to join another party which is having the same ideals?
That is where the anti-defection law comes in place, Honorable Court. If I join another party that aligns with my ideology, then I will be defected as a member. Because the anti-defection law,
Not
paragraph
necessary.
2,
No,
But
but to our understanding and to our reading, subject to you pointing out judgments, of course, uh, anti-defection law, as you just showed us a short while ago, there are
yes,
two circumstances. One is an active defection where he voluntarily resigns.
yes,
Second is a passive nature of a defection where he chooses to abstain from voting along the lines of his party, right?
yes, yes.
Do you have
And
any judgment or any sort of
supporting.
supporting document to show that if a person willingly abstains from towing the party line, as the phrase is, that
yes,
he will not fall afoul of this defection law?
if he doesn't vote according to the party line, then of
And
course
if he
he will.
chooses to abstain, he has intimated the
Hmm,
House that he will abstain from voting, which is his right
15
as a
days.
person.
Yes, yes,
Uh, he has informed the House well in advance. He has not either actively or passively defected, and he chooses to not cast his vote on that issue. Will he still fall afoul of this provision? Do you have any judgment or documents to show?
yes, yes. Honorable Court, if we go by the provision of the law itself, then paragraph 2 gives an exception. If we provide a notice for 15 days, then that member of the party will
Do
not
you
be
have any
defected.
judgments
Yes,
which you
yes.
have pulled out?
Yes. So from this abstention and voting, there is a kind of dicey area because it may also come under voluntarily given up his membership of such political party. Why I say so, Honorable Court? There have been various judgments where this Honorable Court only has held that through express or implied conduct, if the member of the party has expressed that he is no longer aligning with the ideology of the party, then he shall no longer be a member
You
of the
have
party.
Counsel, you are not giving the citation. You're
Yes,
saying there
yes.
are several citations, but you're not quoting any.
Ravi S. Nayak versus Union of India, where this derived conduct thing was stated. Rajendra Singh Rana versus Swami Prasad Maurya, where the question was whether it is split or it is defection, but it was
Can
held
you
that it is
project
defection.
it? Can you project it?
Yes. Yes, I think, Aditya, we need to refer to the main compendium in that case, the 1,000-page compendium. Just a minute, I'll just cite the page number. Aditya, kindly present it if you can.
Yes. Kindly give me a minute, Honorable Lord.
Yes, yes.
Sure.
Yes, it's in page 354. Ravi S. Nayak versus Union of India. Kindly note down page 354.
Noted.
Rajendra Singh Rana is in 342.
354 and 342. Just give me a second and quickly press.
Yes, yes. Meanwhile, if I may please proceed with my submissions.
Yes, please.
342, 350. Yes. Yes, Honorable Court, if I may go on to the third issue that we have, that whether we need certain amendments
Just a
regarding
second.
the regulation. Yes,
Just a
yes,
second. Is this
yes,
what Saksham, give them another 5 minutes, please.
yes.
Yes,
Is
ma'am.
this the case law you were referring to?
Yes, Ravi S. Nayak versus Union of India. Aditya, if you 354,
Yes, this is
page
Ravi.
number 354. Yes. It was held that even from the derived conduct of the member, it can be said, because the question that was raised in this particular judgment, it's a very long judgment, was that whether voluntarily given up membership was based on the conduct, even without any formal resignation. The question that was raised was, the person had not given any resignation from the party, but his conduct outside the house also pertained to something that would qualify or amount to defection. So the Supreme Court quashed the Speaker's order in the instant case, and because it had come after the High Court's judgment, but since even after expulsion, the member of the Parliament should follow the party whip. That was what held in the Ravi S. Nayak versus Union of India judgment. summarize it. It's a very long judgment consisting of various
Sure.
issues and parts.
Please continue.
Yes, Honorable Court. Okay. So I was next talking about whether certain regulations pertaining to the proceedings of disqualification are called for. Over here, if I be kindly referred to paragraph 6 of the 10th schedule, which talks about the fact that the presiding officer of the House shall be the final adjudicating authority in cases of defection. Honorable Court, it is a humble submission on part of the councils that since the speaker is also a member of the House and he enjoys his position because he enjoys the confidence of the members of the House, so therefore an independent, non-partisan member or tribunal should adjudge the process of disqualification. Honorable Court, this very thing regarding the biasness and impartiality of speakers has been observed by this Honorable Court in various judgments like Balachandra Jarioli versus B.S. Yadurappa, Dr. Wilfred D'Souza versus Tomazino Cardozo, Nabam Rebia versus Deputy Speaker, Rajnarayan Singh versus Atmaram Govind, and so on and so forth. Well, whatever be the outcome, time and again this question has arose that whether the speaker is a neutral party or not. Honorable Court, it is a recommendation that either president or the governor should be made the adjudicating authority in cases of disqualification proceedings. Because according to Article 103 of the Constitution or 192 of the Constitution of Indigo, it is the governor or the president who decides these matters, with the only exception to anti-defection law, where the presiding officer is given the authority and the power. And these are not the council's submissions, but was referred to by various committees and commissions. For instance, the Dinesh Goswami Committee of 1990, as projected on the screen, Second Administrative Reforms Committee of 2007, a background paper on electoral
Madam
reforms of
Councillor,
2018. Yes.
Madam Councillor, are you in effect advising the tribunalization of the House? Because if you recall, there is that case of R.C. Gandhi, wherein they have clearly said that, there are a lot of tribunals in this nation. And for every small issue, if a tribunal starts coming up, like what you're saying, that, independent adjudicating body, that essentially is a tribunal. So it will defeat the entire purpose of, you have to refer a matter to an independent body. That independent body will take its own sweet time to come out with its decision. Meanwhile, decisions in the House will be pending. So then how do you how do you harmoniously construct what you are arguing with what will be the ultimate result of your argument?
Yes, indeed, Honorable Court. Regarding the first contention that was raised by this bench, it is, as I already mentioned, that in general, any disqualification proceedings is heard by the president or the governor themselves, with the only exception to this anti-defection law. So I asked this question to myself that why only for one particular reason, where everyday cases are coming up before the court regarding the impartiality of the speaker and so on, why only for this particular case we are sticking to the fact that the presiding officer only will decide it. And the second part of it, Honorable Court, regarding the time-bound nature of the submission, it was my next submission, in fact, that the order of disqualification from the House, whoever be the adjudicating authority, must come in a time-bound manner. Honorable Court, this is because in various cases, for instance, Jagadambika Pal versus Union of India, it has been seen that the speaker has refrained from passing any order in the behalf, and the entire tenure of the legislator, the defecting legislator, came to an end. Therefore, the court was forced to intervene. And not only in that case, in the case of A.C. Sampath Kumar versus Kale Yadiya, 2016, Keshram Mangalchandra Singh versus Manipur Legislative Assembly,
Madam Counselor, do you have any of
2020.
these judgments? Do you
Yes,
have
yes.
access to any of these
Yeah,
judgments?
bring it up.
Yes,
Hmm.
this
Yeah,
is the
definitely.
Manipur Legislative Assembly case where the speaker was given the liberty to decide the case, but despite the fact he did not come up. And in fact, in the case of Rajendra Singh Rana versus Swami Prasad Maurya, the court themselves disqualified. They took the charge of disqualification and they said that those members will not be allowed to enter the house. So, like 7 or 8 judgments I already cited. Already
Yeah.
this.
So, Counselor, I think you can proceed towards conclusion because your time is also running out.
Yes, yes.
Yeah.
Yes, yes, indeed, Honorable Court. So my last submission was what is the scope of judicial review in case of these legislative proceedings? Because as the Kyoto Holohan versus Zachilu judgment already mentioned that there are 2 types of violations of law or allegations that may come up. One is the
Correct.
substantive part and one is the procedural part. So if we look at the substantive part, there has to be a violation of constitutional mandate or malafides or non-compliance with principles of natural justice and so on. And if we look at the procedural part, all the procedures of the parliament come under Article 122 and 212 of the Constitution of Indigo, thereby barring the jurisdiction of the court entirely. However, in very many instances, the court has intervened in the matters. In many instances, the court did not entertain any writ petition. For instance, Prithviraj Meena versus Union of India, which is a very recent judgment. So,
Yeah.
if certain clarity is provided in this behalf, the councils would be much obliged. So, if we may just proceed with the prayer briefly.
Yeah, please.
Please go ahead.
Yes, so the prayer basically sums up all our submissions. The first one being omission of paragraph 4 of the 10th schedule. Secondly, imbibing certain guiding judicial principles regarding post-poll alliances or giving certain legal recognition to party tickets or intra-party deliberative and dissuading mechanisms or about the members who are expelled from the political parties. Also, in cases of mass resignation, as all these were pointed out by my co-counsel, and regarding the submissions that I made, for which should be imposed only for confidence and quasi-confidence motions, and defection intent of the legislator should be analyzed. The independent tribunals should decide the matters of disqualification in a time-bound matter, and the scope of judicial review and the uniformity in the proceedings should be established throughout the country. So
Madam
this sums it
Counselor,
up. Yes.
Yes.
Madam
Yes.
Counselor, one last question before
Yes.
you leave. Are you aware of the concept of the doctrine of separation of powers?
Indeed.
If you read your prayer A, do you
Yes.
believe that this court has the power to grant that prayer? Because that will amount to activism in a nature. And judiciary cannot step into the realm of the legislature.
Indeed, Honorable Court. That is why the prayer has been drafted. Maybe please to recommend an amendment, not
Because
bring in an amendment. Yes.
even if the court
Yes.
is seen to recommend an action, that will mean that there is an inherent nature of a order which is creeping in. How
Yes.
do we prevent that, keeping
Uh,
in mind the doctrine of separation of powers?
Indeed, Honorable Court, if I quote the judgment, cite the judgment of Indira Nehru Gandhi versus Raj Narayan, or for that matter, various other judgments, it has been stated that the separation of powers in Indigo is not so rigid as it is there in the United States or other places. So, if there is inherent violation of the basic structure doctrine, if the fundamental rights of the citizens are being violated, and so on and so forth, then the judiciary has the power to come up and review or enter into judicial activism for that matter to bring in for the purpose of justice, equity, and good conscience. Honorable
Madam
Bench.
Counselor, can you point out to the article in the Constitution which allows this power?
368 is about amendment. Article 368 talks about amendment to the Constitution.
No,
And
what I'm
Article,
talking,
Let her
Article
address. Let her
142,
address.
yes, Article 142 talks about doing complete justice. And Article 144, all the judgments of the Honorable Supreme Court becomes the law of the land.
Okay.
Thank you.
Thank you so much, Aditya and Drishti.
Much
Over
obliged.
to
It was
the
a pleasure.
respondents.
Much obliged.
Is the council audible and visible?
Yes.
Yes.
May it please my lords, this is council number 1 for the respondent, the Union of Indigo. The council solicits permission to address the bench collectively as my lords.
All right.
Sure.
Much obliged. The council solicits permission to share screen in order to share the compendium.
All right. Please go ahead.
My co-counsel shall be doing the same. Much obliged, Raj.
Just a second, I am presenting.
I'll be beginning with the arguments and will refer to the compendium as and when needed.
All right.
So the council solicits
Please
permission.
proceed.
Much obliged, Your Lordship. So the first issue that we have at hand is whether the provisions regarding intra-party dissent are unconstitutional in nature or not. So the 10th schedule of the Constitution does not violate any fundamental or constitutional rights, as the rights itself are not absolute in nature and can be with reasonable restrictions. The constitutional validity of the schedule has been upheld by the Honorable Supreme Court in the Quixote Holohan versus Lucilu 1992 SCR 1 686 judgment, which has been referred by my learned opposite counsel as well. The Honorable Court in this case has adopted a restricted view of the direction issued by the party that the violation which may entail to disqualification, such direction should pertain to two matters. One is, that is A, a vote on vote of confidence or no confidence in the motion, and second, when the motion under consideration relates to a matter which is integral policy and program of the political party on basis of which it approached the electorate itself. This has been done in a view to maintain freedom of speech of the members in the House, guaranteed under Article 105 and 194 of the Constitution. Therefore, my lords, it can be seen that neither of the acts, neither of the articles, that is Article 19(1)(a), that is freedom of speech, or Article 105 or 194, which are specifically for the speaker, for the members of the House, the rights are not being violated in any way. The council, for the sake of brevity, will not repeat this judgment again and again, as it is a landmark 5-judge judgment, which is already declared, already considered all the aspects of this present case here, and decided to declare only paragraph 7 of the schedule ultra vires, which curtailed the power of the courts. But still, if we go to 174, page 174 of the compendium, we come to para 122b of this judgment. It can be understood that para 21b, which says any directions, which means that any direction has to be read in a narrower sense in order to harmoniously construe it, so as to not impine on the freedom of speech of member of parliament or the state legislator under 1051 or 194(1). Accordingly, the directions given by the political party to a member belonging to it, the violation of which may entail disqualification under para 21b, would have been limited to a vote of motion of no confidence or in a motion in which it reiterates the policy of the government. Therefore, the schedule in a way ensures that members of the parliament don't back out from their promises, which they made to the public in general, by ensuring that they vote in favor of the party mandate or the manifesto as decided by the party leaders even before the elections, and on basis of which the electorate was won. It is on this mandate that the public at large had voted for them and had voiced their opinion in favor of these candidates. Therefore, this schedule makes sure that the candidates vote in that direction. The members of the House have been given a wide freedom in all aspects and can also dissent to the party in the party meetings. But certain restrictions have been imposed with the schedule to secure the ends of justice for the people's mandate. My lords had pointed out during my learned opposite counsel's arguments that whether such a permission can be granted to abstain. So, my lords, this council shall refer to page number 216 of the compendium. That is Dr. Manchandra Prasad Singh versus Chairman of the Bihar Legislative Council, published in AIR 2005 of the Supreme Court. In this paragraph 15, subclause subintent C, if we refer to, clearly states that it can only be with reasonable restrictions, and the same can also be used to take a condonation from the party or any authority to abstain from voting. And this need not be in writing. It can be taken orally as well. Such a wide power has been given to all the members. No fundamental right or constitutional right of the members are being violated in any manner. The effect of the schedule is only limited to ensuring that members of the parliament do not switch between parties and a stability in government is maintained along with fulfilling of the manifesto given to the people by the party, thus holding them accountable for this manifesto. Each and every member of the parliament can be held accountable. And if they are not following the party manifesto, they can be held against it. My fellow learned counsel also pointed towards violation of rights, but
Counsel,
yes, my
when
lord.
you are saying that we can hold them against it for not following the party mandate, are you saying that the individuals themselves, they cannot feel that their principles are against the party mandate if the party mandate has changed over the due course?
My lords, had the party mandate changed, the member of the
It is not
parliament.
unheard of. It is not unheard of that the party mandates have changed. It is not unheard of where parties have made promises, but they have not stuck on to their promises. So an individual who is a party worker, who is a party representative, must have felt that the party is not going in the direction. Why is he not having that kind of freedom?
I completely bow down to my lords. My lords are completely correct in this manner. But the only difference is that the party has won the election on that mandate, on that electorate. And when a party is working
The
towards,
party has won the mandate only because I have got the votes for that constituency.
indeed, my lord, that
If
is
I am feeling that my party is not following the mandate that has been portrayed before, then I can definitely take my people with me and go to a party which is going for the mandate that they have promised, which is in lines with my view.
I 100% agree with my lords. That is why, my lords, a power has been given, as discussed earlier. If I feel that if the member of the parliament feels that something is against his own moral values, he can go to the party and take a permission to abstain from voting. Or if completely he feels that there is a completely large dissent in the party, a two-thirds majority is being formed, then there are majority provisions which my co-counsel shall be dealing with of how the merger provisions are completely constitutional and why they are important for this for the purpose of this for the schedule.
Counselor, you had pointed out two aspects. One is constitutional right, the other is fundamental rights.
Indeed.
So is it there is no fundamental right in a person to shift his goalpost just because he is not happy with the party leader's face one fine morning. So can you distinguish between a constitutional right and a fundamental right in this context?
Indeed, my lords. So the fundamental right that has been granted to an individual, even that is with certain restrictions. But in this aspect, if we understand,
Is it a constitutional right or a fundamental right to shift? I mean, today, if I want, nothing prevents me from going to other except this law. So, as the counsel for the government, do you feel that having this law in its present shape and form today is not restricting my free will and my free right to, bring forth what is best for my candidate, my legislative poll. Like so, wherever I am representing, I should bring those people's viewpoints also across. So if I'm not, or I'm actively prevented from bringing those viewpoints, so is it a constitutional right which is coming in my way, or is it a fundamental right which is coming in my way?
my lord, it has never been recognized as a fundamental right. It will, if we have to argue for argument purposes, in arguendo, we can say that a constitutional right is there. But a fundamental right of this nature has
So
never.
you're basically saying that it is not enforceable in nature, essentially, what you're saying.
Indeed, my lords, because now when the people have voted in favor of one thing, it is assumed that the people have voted in favor of the manifesto. And when a party is working towards in direction, let's say FDI, if one party in the manifesto has asked for the FDI, and now the member of the parliament of the same party, when the party makes a bill for FDI, goes against it, then the people can hold the person accountable. Therefore, this law helps in ensuring that all the promises made are being fulfilled by all the people in the party, not just one. This is where the law is ensuring that all these promises and everything does not come in the nature, does not hinder the public policy and does not hinder the growth of the people, the public at large.
All right. Thank you, Counsel.
Okay.
Much obliged, Lordship. Similarly, my lords, just to give a brief, what my lords had pointed out during my learned opposite counsel's arguments, that they did not delve deeper into which particular article is being violated. And there was no intelligible differentia, that is, the differentiable capability of being understood, that how the law is to treat all individuals similarly or not. Like we see in Article 14, the difference for SC and ST. No, they even mentioned...
Saksham, give them a 5 minutes additionally.
Much obliged, my lords.
Please proceed.
Similarly, the learned opposite counsel also mentioned how the basic structure is being violated, but they did not mention what do they understand by the basic structure and why is it being violated, in what ways. They did not delve deeper into, but they made just striking remarks. It cannot be taken that way in this court, my lords. Coming to the second issue, my lords, whether the provisions regarding merger are unconstitutional in nature. Very slightly, I'll refer to it. The 10th schedule is a complete code itself, and can be ascertained by a fact that it also has envisaged a situation where not just a member of the party, but a majority of the members of the party and the party as a whole are merging with another to form a single party. As this situation is not so uncommon in the political setup in our country, a special provision has been provided for the members of such a merging party in order to ensure that they do not get terminated by virtue of this schedule. The schedule has been brought in with the legislative intent, which can be established from the parliamentary debates, that stability is as to ensure and hold a member accountable with only one party having the same ideology, and it has contended elections with. The schedule has therefore introduced a term called political party under the term legislative party, which refers to a party on whose ticket the member of the parliament was elected and voted in.
Counsel, I have a question here.
Please, ma'am.
Are you saying that articles can contradict schedules?
No, my lords.
You said the schedule was introduced to bring in the definition of political party. My question to you is, can your schedules in the constitution, can it be contradicting the articles?
The council is deeply sorry for this confusion. I meant under the term legislative party, they have also distinguished what do they mean by the original political party. As under the 10th schedule, there is a term of original political party, which ensures that the ticket on whose member of parliament had won the electorate on.
Okay, please proceed.
So in this term, it has created a specific bar between the members leaving the party and the party as a whole merging into another party. It has been well defined by the High Court of Bombay that on a bare reading of section 5(2), it makes clear that merger of the original political party or the front with contemplation and further agreement of not less than 2/3 of members are important. The term original political party still have to be construed as defined in 2J of Disqualification Act to mean political party, which is proposed candidature. So as held in, if we refer to page 562, which is the judgment of Shah Farooq Shabir of Govind Rao Ramu Vasave, reported in 2016 SCC Online Bombay 5451. Para 75 of this judgment, the operation of the schedule is exclusively intramural or confined to the four walls of the house. If the intention of the parliament is enacting the schedule, it is to confine the speaker merely to count the numbers of the legislative party. There is no mechanism for the original political party in para 3, 4 in connection with the merger. There is a built-in mechanism in the schedule to maintain a nexus between the political party and the legislative party, which is essential for the effective functioning of the parliamentary form of government. The schedule casts a duty on the speaker not to lose sight of this nexus while formalizing a merger. Therefore, it can be understood in a simple manner that the legislature, by adding protection for mergers, intended to ensure a more stable government, wherein two parties having similar ideologies could merge into and resultantly form a government which was free from any form of undue which could have been a scenario if parties, which couldn't have been a scenario if parties were not allowed to merge or form a coalition. Additionally, my lords, my learned counsel in the written submission has contended that the speaker will not be the correct authority and shall be partial towards his or her party. Firstly, my lords, it must be understood that the speaker's order shall be presumed that a fair process is followed with a detailed written order, giving reasoning for the order by the speaker. Secondly, my lords, the same order can be challenged in the courts, and the courts have complete jurisdiction for judicial review if any bias is felt. The learned opposite counsel themselves stated a plethora of judgments in which the courts have dealt with such a case and made sure if a bias was there, that can be corrected. And there have many cases in which the bias was not found to be there. Additionally, my lords, to understand the powers of the speaker or his or her fairness, it can be ascertained from the fact that when in Lok Sabha, a vote is stuck, when there is a deadlock, then a speaker's vote is called a casting vote. It is used to break the deadlock in a deliberative way. The speaker only exercises this casting vote in a case where equality of votes so even that even then it will be unconstitutional. That and also
Council, you'll have to wrap up. Your second speaker has to speak up.
indeed, my lords, just 10 more seconds and the council will wrap up.
Sure.
The council would just like to state that the appointment of the speaker also, if we understand, is similar to what we see of how the president is appointed, although wide difference in powers and what we see over here. But now the authority given by the virtue of office and in respect of the office being held by the person who is appointed as a speaker shall be assumed that there will be a fair process. Therefore, my lords, the council would like to call upon my fellow council for the next issue.
Yes, please.
Much obliged, Lordship.
Lords, am I audible and visible?
Yes.
Grateful, my lords. My lords, so I'd like to take forward on the aspects of the constitutionality regarding the provisions of the speaker under the 10th schedule of the constitution, as my co-counsel had dealt with. So, as per paragraph 6 of the 10th schedule of the Constitution, my lords, the question as to whether a member of the House of the Parliament or the state legislature, as the case may be, has become subject to disqualification will be determined by the Speaker or the Chairman of the House, and his decision shall be final. The powers and functions of the Speaker has been considered by the Honorable Court, as also has been dealt enumerated, in fact, by the councils on the other end, my learned counterparts, has been considered by the Honorable Supreme Court in various cases, where the Honorable Court has clarified and propounded various principles for the Speaker to keep in mind while exercising his said powers and functions. The fundamental challenge as to the provisions of the Speaker, provisions regarding the Speaker as being the sole person who is presiding over the act of defections per se, was introduced as a part of a challenge in the landmark judgment of Kehoto Holohan versus Zachilu. The majority judgment in Kehoto, in which Justice M.N. Venkatachalaya, on his behalf and on behalf of his two learned brothers, had unequivocally upheld the constitutional validity of the position of the Speaker as provided in the 10th schedule. I would like to go through the specific paragraph if my learned co-counsel would present the same. Vedant, if you'll just present.
Are you projecting this?
Yeah, they want to.
Yes, my lords.
Please allow me a minute, my lords.
Vedant, please come to page paragraph 115, page 170 of the compendium. Just give us a second, my lords. Page 170.
There's not much of coordination between you both.
My lords, I think the laptop is acting up.
Vardhan, you just have to type 170.
Paragraph 115. Yes,
Yeah.
my lords. If I may take my lords through the paragraph.
Yes,
The
please.
question is whether the investiture of the determinative jurisdiction in the speaker would by itself stand vitiated as denying the idea of an independent adjudicatory authority. We are afraid the criticism that the provision incurs the vice of unconstitutionality ignores the high status and the importance of the office of the speaker in parliamentary democracy. The office of the speaker is held in the highest respect and esteem in parliamentary traditions. The evolution of the institution of parliamentary democracy has at its pivot the institution of the speaker. The speaker holds a high, important, and a ceremonial office. All questions of the well-being of the house are matters of the speaker's concern. Speaker is said to be the very embodiment of propriety and impartiality. He performs wide-ranging functions, including the performance of important functions of a judicial character. So, my lords, it is humbly submitted that the provisions, the position as regarding the speaker as held by the court in the landmark judgment of Kyoto is one of judicial nature. Now, my lords, tomorrow, if the petitioners up and say that my lords has a political affiliation, and on that basis, my lords will not be entitled to hold office or rule on a judgment, or for that matter, the president itself has some political affiliations. Of course, the president, being a political creature, has ended up at the post of the president. It is not someone who is completely apart from politics that ends up as a president. And tomorrow, if this argument is taken on its merits, that would render the whole judicial process infructuous. My lords, in that regard, it is humbly submitted at the outset. In light of the judgment of this honorable court in Kyoto, the law has already been settled, and the principle of res judicata shall squarely apply and would be fit for application at this juncture itself. But in any case, my lord, I would be taking my lords through the merits of their case as well, and would showcase how their case is untenable before this honorable court. The powers and functions of the Speaker, my lords, has been considered by the Honorable Supreme Court in various cases, and the Honorable Court has clarified and propounded various principles.
Can
as I
you
have
bring
told
up
you
any
before.
of these cases? Can you bring up any of these citations?
Yes, my lords.
There is one more question that you will have to address is on the unbiased nature of the speaker. How are you saying that he can be completely unbiased when he has come into that position by the power of vote? He has come into
Indeed, my
power
lords.
because he was belonging to a particular party. So
Indeed, my
how are you
lords.
going to address that? How is their unbiased nature in the true sense?
I'll just, if my lords give me a minute. My lords,
Counsel, your co-counsel can bring up the relevant provisions.
While you continue.
yes, my lords. My lords, I would like to take your pardon on the presenting part. I would like to, if my lords are persisting on the presentation part, I'll just take out the judgments, my lords. I had initially not added the judgments in the compendium. So if I could,
Yes.
regardless of that,
You
take
did
my
not
lords
add?
through.
Are you saying you
I
did not
did not
add?
add. Yes, my lords, the judgments that I have cited right now in my oral arguments, I have not added in my compendium. I apologize.
Okay.
Mr. Counsel for the
So I
Union.
would not be able to. My lords,
Mr.
I
Counsel for the
apologize for
Union.
that.
How can you represent a government like this?
Yes, my lords, I absolutely understand.
Okay. Please address the question.
Yes, my lords. In terms of bias, my lords.
Yes.
Yes,
How can the
my lords,
speaker be
as
truly unbiased when he is in power because he was belonging to a particular party?
yes, my lords. So, my lords, as I had already stated, as I had already taken my lords through paragraph 115 of the judgment, my lords, the office of the speaker, the position of the speaker is inherently considered a high constitutional and a functionary position. Therefore, my lords, and that position, as I also drew a parallel to my lord's position itself, as being one of judicial nature, as has been held in that judgment, it cannot in a sense stand the question with regards to bias, my lords, in that case, every person would be having human considerations, and anyone could have a political bias. But the position itself, my lords, is coveted with a higher constitutional function. Therefore, my lords, that question would, in that regard, stand answered. May
Mr.
I
Miglani.
continue my arguments? Yes, yes, my
Mr.
lords.
Miglani, are you aware of the doctrine of pith and substance?
Yes, my lords.
Can you apply what is the essence of this anti-defection law as per the union?
My lords, the essence of anti-defection law is, if I put it to you simply, is that in order to avoid the breakdown of the parliamentary democracy in our country, in order to safeguard the basically the rights of the parties itself, because parties are in our democracy considered as the main face, or the main representatives of people rather than the individual itself. That was the intention of the legislature in bringing about this law itself, that the people identified with not the individual rather than the party itself. For example, if I today vote for a candidate, it might be a very big consideration which party that candidate particularly belongs to.
But it's not very efficient, isn't it? I mean, in today's day and age, despite all what you're saying, it's not a very efficient system that we are having in place, isn't it? Because the point of one switching to the other party, it is still prevalent.
Well, that is true. It is not the state's case that this law is without its loopholes, but for a matter, a law having loopholes cannot make it stand make the law unconstitutional itself. Of course, my lords have propounded through various judgments that they have propounded on the principles that are to be followed by the speaker with
Please
regards to
quote a
various
few,
judgments.
please.
Yes, my
Counsel,
lords.
please, when you're saying
I will.
there
I
are
will.
several judgments, I would like you people to quote and also state as to
Absolutely, my
what it
lords.
is. Yeah, please.
Absolutely. So, in Manilal Singh versus Dr. H. Bora Babu Singh, a 1994 supplementary 1 SEC 718, it was held that in case the speaker does not implement the order of the
You
court,
have access to this judgment?
He
my
didn't put
lords,
it in the compendium.
that's
what he
what
said.
I'm
Okay,
saying. This was a
we
last
go ahead
moment
on that
Please tell
point.
the
addition.
ratio. Please
Yeah.
tell the ratio.
Some of these were last moment additions, my lord. I really
Please tell the
apologize,
ratio.
but be rest assured, if my lords want, I'll pull out the judgments right now.
No, go ahead.
Please tell the ratio.
Absolutely, my thoughts. Grateful. So, my lords, the ratios in in these cases, for example, in Manilal Singh versus Dr. H. Babu, that the speaker, if it does not implement the order of the court, in case a review goes to the court and it does not implement the order of the court, the contempt can be initiated against the speaker. Further, my lords, in Dr. Kashinath G. Jalmi versus the speaker 1993 to SCC 703, held that a speaker assuming an office can neither review his own order or the order of the previous speaker nor his own orders. The remedy against disqualification orders would be on the ground of defection would lie to the constitutional courts, which my lords are. In Nabam Rabia and Bamang Felix versus Deputy Speaker Arunachal Pradesh Legislative Assembly 2016-8 SCC 1, the Honorable Justice Deepak Mishra observed on the constitutional position of the Speaker and strengthened the moral argument as what my lords had just asked. One, after the constitution came into force, as it is evident from the constitutional scheme of ours, the speaker enjoys high constitutional status and is expected to have a sense of elevated independence, impeccable objectivity, and irreproachable fairness, and above all, absolute impartiality. The expectations is the constitutional warrant, not a fond hope and expectation of any individual or group. My lords, Justice Deepak Mishra, in all fairness, he in 2000, this is a 2016 judgment, my lords. If an argument is to be made that okay, the judgment of Quixote was a 1992 judgment, and recently there have not been developments on the same, my lords have been consistently facing the cases where the law has been put to test and have been all this while have upheld the provisions, and for that matter laid down various guidelines at various junctures, rather than invalidate or render the whole law unconstitutional. It would also be pertinent to mention that post the judgment of this Honorable Court in Kesharam Meghchandra Singh versus Honorable Speaker, Manipur Legislative Assembly, 2020 SEC Online SC 55, where the court fixed the time limit of the decision to be taken by the Speaker as to 3 months. The council at the other end had contended that the Speaker has indefinite time in order to decide a petition with regards to defection, but that is not the case anymore. That legal position has now stood changed, and the same is that the Speaker has a time limit of 3 months to decide a defection petition. All the above judgments that I've stated, my lords, they showcase one thing, that my lords have frequently and all this while they have upheld the provisions of the anti-defection law. Apart from that, my lords, for the sake of argument, even if what my learned counsel on the opposite ends are contending is to be given into by my lords, the position will arise that there shall be no anti-defection law itself. And in that case, the very purpose of the petitions of the petitioners itself will stand vitiated, and the position shall be exactly opposite to what they are intending to get to. I am grateful for my learned counterparts. The examples of defection that they have given further buttress my argument that in case the anti-defection law is rendered unconstitutional by my lords today, the same would result in a precarious situation for the parliamentary democracy system of India, as the horse trading would, as far as it is concerned, as they had contended, would increase exponentially. So, my lords,
Council, try to wrap up. I think your time is up.
yes, my lords, I'll just end my submissions here. My lords, lastly, just the reliefs that are prayed by the learned counsel, learned counsel by the other end in their petitions is not maintainable. In the very recent case of Suprio versus Union of India, Honorable Justice D.Y. Chandrachud, Honorable Chief Justice D.Y. Chandrachud had in his judgment held that the legislative function of the parliament cannot be taken over by the judiciary, and hence the prayer itself of the respondents of the petitioners is untenable. With that said, my lords, I'd like to just take my lords through our prayer and
Sure.
conclude my arguments. Grateful, my lords. My lords, my lords, a simple prayer is today is that a judge and declare the law of anti-defection as introduced by the 52nd Amendment as constitutional, as has been held by this court in various cases before it, and dismiss the petition of the petitioners. That will be all, my lords.
Courtmaster, do we open the floor for rebuttal?
Yes, it depends on your discretion. If the judges want it,
Yes.
we can.
Petitioner, you can start with your rebuttal, followed by the respondent.
Indeed, Honorable Court. So,
3 minutes.
No,
Sorry.
yes, go ahead.
yes,
Let's keep it short and crisp, because I think we've already gone beyond the prescribed time limit. Yes?
yes.
Okay.
Indeed, Honorable Court, my learned friends on the other side, it is to clarify that the entire petition of the petitioners is based on the theory of transformative constitutionalism, as was held by this court in the case of Navdeep Singh Johar versus Union of India, where they themselves have agreed that there are certain loopholes in the law that need to be addressed. And our prayers in these regards have been very specific. We not for once mentioned that the anti-defection law should not be there, but certain changes regarding to the nature of whips, regarding to the adjudicating authority, regarding the time limit for which only a judicial pronouncement was there, but again, there have been violations of that judicial pronouncement. Regarding the time limit, regarding the scope of judicial review, on the light of the various statistics that was given, we have come to the court as a public spirited NGO. And regarding the basic structure doctrine, Honorable Court, It was held in the Keshavananda Bharati versus State of Kerala case that parliamentary democracy forms the basic structure doctrine. And in a parliamentary democracy, things like freedom of expression of the legislator that is being curtailed, who is a representative of the constituency. I mention it again. And also the exception to the president's and governor's power under Article 103 and Article 192 that is being laid down under the 10th schedule. All these do not fall within the definition of just, fair, and reasonable as was held in the case of Maneka Gandhi versus Union of India. So I think that would be it for mine.
All right. Respondents?
Manoj, I shall be taking the rebuttal. Manoj, with regards to the part where my learned co-counsel, the co-counsel on the other hand has said that I have just challenged the specific parts of the 10th schedule. Manoj, I would like to contend that the parts which have been challenged are the essence of the law itself, and they are not severable in nature, Manoj. In case paragraph 2 is rendered infructuous by my lords, the entire schedule itself would lose its whole viability. In case paragraph 6 is rendered infructuous, as the challenge has on speaker, the position of the speaker has been clearly evident. The provisions with regards to paragraph 8 as well as paragraph 6 would be rendered infructuous, and for that matter, any single provision of this this whole 10th schedule, apart from what paragraph 7 used to be before my lords had held it unconstitutional, it is not several. Therefore, again, I buttress my argument that the prayer itself of the petitioners is untenable in nature. And my lords, if my lords would award the same, it would be grave injustice. And coming to another point which was taken up during the course of the arguments, that the procedural aspect of the speakers taking up the defection petitions cannot be challenged in courts. My lords, the same immunity has been granted to the proceedings before the parliament, and not only to the speaker itself. The parliament has and enjoys its immunities, and the same have been rendered constitutional by this honorable court. I would like to end my submissions there, my lords.
All right.
If there's any no
Thank
other
you.
question.
Thank you, both the teams.
Thank you.
Grateful, my lords.
I think we can conclude on that. Courtmaster, is there anything else?
If the judges want, they can give their feedback to every speaker.
So, yeah, I would give my feedback first, after that followed by Daniel. Both teams, both of you all performed very well, especially with regards to impromptu questions. You all were perfectly on point. You all were equipped with your answers. Both of you all were well prepared. But respondents, if you all are going to the next round, you all need your citations to be handy. You cannot be saying that I apologize. No, that won't do. Petitioners, you all were very well prepared in the matter of projecting your technology, whatever you all are following, very well done. And yeah, I think both of you guys, 4 of you people, you were very good. You all did a very good, fantastic job. Congratulations on reaching till this level, and I hope you all go forward also.
Thank you, thank you, ma'am. Actually, the thing is, with regard to the presentation on my end, the issue was connected. That is why it disconnected once. But I'm really sorry for that. It is no excuse.
No, we all do have a technical glitch, but Sarthak here said that certain of the citations were not there in your compendium. That is something which is surprising. I mean, you're representing the government, right?
Yeah.
I
Yeah,
completely
ma'am, absolutely. I had made the compendium, and today I had tried to access the same, and it was not downloading through SCC for some reason. I had decided to still take up the cases because I had to
No, that's
present.
what I'm saying. You guys were well prepared. You all were very well equipped for whatever questions we threw at you guys. You all answered well. We're happy that way. But yeah, other than that, I don't have anything more to say. Over to you.
Nothing from my side particularly. Just good luck, and hope that you guys go ahead and go into the semi-final rounds and further finals. Hope to see you.
And also do well in your in your next leg of your career also. Thank you, guys. Thank you so much.
Thank you, ma'am. Thank you, sir.
Thank you.
Saksham, I think we have to send out via email, right?
Yes, ma'am. The invitation,
All
the
right.
email through which you received the invitation. you
Sure,
have to
sure.
send it through.
All right. Thank you, guys. Thank you so much.
Thank you, everyone. We end the
Bye-bye.
competition over it. All the very best for future rounds. Thank you.
Bye-bye.